I know some folks will still be joining us, but we'll go ahead and get started for the sake of time. Welcome to everybody who is on the call. This is the third and final series of the estate planning by Andrew Branan, and we appreciate everybody participation and the great questions we've had. We are recording these, as I had mentioned before. Because of some other projects we had going on in the last week, we did not get a chance to get the second series out in time, downloaded and in time for everybody to be able to look at it. So we apologize for that, but we will get all three of these out for all of you who maybe could not attend the first one or two. But all three will be available. You will see that you'll need to register to get the link for them. That is simply so that we can kind of keep track of who all is looking at them. And that's the main purpose, is because we have to report back to our grant funders about how many people we reached and their background, farming background or non-farming. Andrew's got a slide on who all of our presenters are. So in the past, if this is your first time joining us, what we've done, it seems to work well. As you go through, I know there's a lot of information that Andrew's going to be giving us, and we ask that you put a question in the chat box as we go through, and at the end, he will address all those questions, and we will continue to keep the presentation going as long as we have questions at the end. So, we're not going to stop it directly at 1:30. Last week, I think we ran almost till 2 o'clock. We realize some of you may not be able to stay on, but I will keep it recording so those answers can be listened to when you're listening to the recording. With that, I'm going to turn things over to Andrew and let him tell you a little bit about himself and talk to us about the final series.
Thanks, Gail. So hey, everybody. For those of y'all who've joined in on parts 1 and 2 of this, you already kind of heard, about me and what I do. Those of y'all who are just joining this part for the first time, I'm an assistant extension professor, Department of Agricultural and Resource Economics at NC State. And my area of, I guess, extension and research and teaching is law. I have been, next month, I'll have been working in this realm of conservation easements and agricultural law and land and farming and all sorts of things for about 20 years now. I spent near 10 of that, a decade in private law practice. So a lot of what I, try to bring to the table for extension are those experiences and things that I've learned just being around farming and being around land transactions and all of that. And I've been thinking a bit about, how to approach this this part particularly because we're moving into a realm of, I thought I would say, what would you do, Andrew, if you were presented with this type of project, this type of issue where there were some specific goals for subdividing a parcel of land among what I would call devisees of a will or beneficiaries of a trust, but also take advantage of a conservation easement opportunity. And so the way I wanted to approach this today was to say that, I've again, in my practice experience and my time doing this, I'll say I transacted I think about 5 or 6 conservation easements, dealt with many more in estate planning because I might have been working with a client who wanted to do some estate, develop a trust, things like that, but they had property that was already in a conservation easements. But I most often when landowners are working with a conservation easement, they're most often working with a land trust or an entity that's going to be doing a lot of the heavy lifting, working with the funders within RCS, with the Ag Development Trust Fund. And so if I was working or reviewing a conservation easement transaction, somebody else might be doing all that work, but I did have the opportunity to develop several projects working directly with the funders because I was working for an entity, I was working for the landowner, but with an entity that just didn't have that staff. So I was it. Most lawyers look at it and go, why are you, that's not really high level work. I've found it hugely beneficial in understanding the moving parts and the timing and the challenges and some of the frustrations of trying to keep all those parts moving along. And so this topic here, I called it the impact of conservation easements on real property decisions. And the overall theme for today is we're interested in a conservation easement on this parcel of land, but we would also like to maintain or retain some flexibility on the part of our devisees of the will for the land, our beneficiaries of a trust perhaps for the land, and what are those options there? And so doing the research and going in and seeing what the limitations are on that flexibility, that's the approach I've taken. And so I'm going to try to put the pieces together and show what I would be looking at if I was looking at a map of a piece of property and what the timelines might look like. But there are so many moving parts that I think we'd all get a little too dizzy doing that. So I'll just point out where it is I would be, where I would expect an estate planning attorney, any attorney that's dealing with this particular question on a part of a client, where they should be looking to find out what the options are for the client. And I'm not covering all the options. That's continuing work. So again, a little shill on my part, just for those of y'all who hadn't joined, just remember I have a website, web portal through Cooperative Extension. This is a screenshot here. And it's where I say I hang all my work. It's where if I write something in draft or get it peer reviewed, get it published by extension as a fact sheet, whatever happens to be, you can find it here. On this site, in the Farm Succession tab, there's a handbook that I published with the help of Tobacco Trust Fund last year, and so that's there in PDF. And I'm always still working on this. Those of y'all who know my past work, I had a workbook called Planning the Future of Your Farm. That's also on the site, and I've been continually updating that one for a while now, maybe 10, well, more than 10 years, maybe 15 years now. And then also you'll find things on the website like various webinars and stuff like this, including this one. I'll make sure that when Gail and them edit this down, I'll cross post it to this site. So I realized in going into this, and we haven't gone through this in the past two sessions. So perhaps I can quickly do the easements 101, the conservation easements 101. We normally think of conservation easements as what we call permanent restrictions on a right to subdivide, or permanent restrictions on certain land uses, like overly extractive things like mining, stuff like that, in order to preserve the conservation values of that parcel of land. And the reason we call it permanent is because there's no mechanism by which the rights that you grant, but either by sale or donation, but normally a combination of both, to that third party to hold. And again, on behalf of the public, they're holding it on behalf of the public. It's not as if you're remember this, the analogy that I used for the bundle of sticks. You're taking your right to subdivide that parcel out of the bundle of sticks and handing it to someone else. And in that deed of transfer, there's no mechanism by which that stick returns to your bundle. There's a little escape hatch in our state law on a reconveyance option after, I think, 20 years. But generally, once that stick goes out, that third party holds it. Now, that stick doesn't give them the right to do anything other with that stick than access your land to monitor the restrictions that that stick represents. And under federal, I think under state law, probably, I'm sure under federal tax law regulations, the organizations have to have a successor. And so my point is there's no mechanism by which that stick returns to that parcel's bundle. And so we consider it to be permanent. How you value a conservation easement, I'll do a quick example of that. But these are the concepts to be familiar with when we talk about conservation easements, and these will come up, you know, throughout this particular presentation, particularly in terms of decisions on subdivision. Of course, highest and best use. That's and I'll go ahead and admit to you all, this is a slide I took straight out of my ARE 306 and 309 courses, because I do teach conservation law to the 4 and the 2-year students at NC State. And these are just terms to be familiar with. So highest and best use, I'm sure we all know what that means. It just means that that's what the market would, if you know, between a willing buyer and seller, what an appraiser would value the property at. And we do this, you know, we appraise property for lending purposes, for use as collateral. All counties appraise property at its highest and best use for property tax purposes. And so the regs, I don't know if it's changed recently, but I've researched it before, and I've always assumed it's a certified appraisal, but the regulations are a little bit vague on that. But every transaction I've ever been aware of has an appraiser that comes in, certified under North Carolina law, that that does the highest and best use valuation. And then in that same body of work does a restricted use appraisal. And that's what the appraiser's best work is on. If we were to remove the right to subdivide, if zoning in this area allows for minimum 5-acre lots, and this is a 100-acre parcel, and you could sell 20 of those lots, or you could sell it to a investor developer group, and they would do that. If you removed that, then that reduces the value of the property, and so still has value. And so, but that value is ascertained, and you have a high and a high best use value and a restricted value. And that becomes basically the value of the development rights that are going to be transferred, the value of that stick, so to speak, that's going to be pulled out of the bundle. I've already explained the permanent part. I didn't finish here. I said, but C, I was going to put in a statutory reference that I'll reference here in just a few minutes. The concept of permeable surfaces. This is also a factor in decisions and either what's allowed under your ability before the fact to design how this parcel might be subdivided in the future, even under conservation easement. But will also factor if after the fact, if one day down the road, the option was left open, but the subdivision still is yet to be designed, meaning just how the parcel is divided up. Permeable surface will factor in, because one of the key features of a conservation easement is to maintain the permeable surface of the land, reduce rooftops, paved roads, parking lots, anything that's going to cause water to run off fast and not absorb into the soil to recharge groundwater and otherwise slow the flow of water, which is a source of water quality degradation. And then there's the building envelope. And the building envelope, of course, is really a pre-designed area that shows up in the baseline report, and it's agreed to in the deed of conservation easement that this particular area here that more buildings can be built, or more impermeable surface can be established, a lot or parking lot or roofs or something like that. But generally it's the landowner reserving in the transaction the ability to expand a certain area. And when we're doing it in farming, or on a farm that's capable of supporting an operation, a lot of times we want to be able to expand the farmstead, the shops, the things like that, redesign them, expand them, whatnot. But a lot of time landowners also wish to set aside perhaps possible building locations for a cottage or another house. things like that. And when we talk about building envelopes and what's possible, that factors into our subdivision or our property subdivision decisions based on, you know, what type of structure can be built there. And it all, what also will factor into that is, where does the money come from to build structures if the property is not divided? Because of course, if you're builder, you know, financing that construction, the parcel that's supporting that structure is going to be used as collateral. And so how the land is subdivided means whether that certain little parcel there is going to be used as collateral, or if unsubdivided, the whole parcel has to be used as collateral. So the funding, again, this is, you know, this is just I think what I consider to be the main sources. Of course, we have the federal from the Farm Bill, the ASEP program. We call the purchases agricultural conservation easements, and that funding comes through NRCS. National NRCS allocates funding authorized by the Farm Bill and then approved in the budget across the nation, different amounts to different states. And then that state has that pot of money, and it becomes their competitive pot of funds to pay landowners for purchases of development rights. Normally, this is going to be combined with our state source, which of course is the Agricultural Development and Farmland Preservation Trust Fund. I put in paren upland projects because in my mind, I've sort of divided, and just at least working with working farms on this, even though there's always a water component, or almost always there's water running through the farm. I see these really as upland soil preservation projects. And then we have another fund, the Land and Water Fund, which I'm not as familiar with. I've never transacted what in my time in private practice would have been called the Clean Water Management Trust Fund. It's been renamed in recent years, but I see that more towards what I call riparian projects. Projects that are going to directly improve water quality or create floodways or things like that. And then a third source I would say would be private donations. Land trusts have development staff that do cultivate, support. I've said wealthy donors because I mean that's, if you're going to do that if you have money, and I've been in transactions where that's been a small component. It usually won't be the majority of the funding, but it will be a bit that comes in that also helps get the purchase price to a place where the landowner is agreeable. And then at least some portion of that, and again, in my experience, has been there is going to be some donation, some give on the landowner's part in terms of the value of the land. Sometimes, with the land trust, there's a request for a cash donation to go into the monitoring fund, because the entity that takes the conservation easement, that takes that stick, they have an obligation to monitor. And that costs money. That's time and money. So here's just an example of how the money works. And this is super duper simple, simplified rather. I have a 100-acre parcel where, let's say its highest and best use is at $1 million. The appraiser has tagged its appraised its restricted value at 650. So and look at this, I hope I've done the math right. I've valued our easement at $1 million minus 650, $350,000. And so, as a quick aside, one challenge that I've observed, and have gotten questions on and sort of been in the middle of here and there, when a conservation organization, whether it's a land trust or it's a soil and water conservation district, is going to enter into this process with the landowner, in order to start work, the entity wants to have some guarantee that the project is going to make its way to the end, that the landowner or the landowner's heirs can't suddenly say, hey, you know what, we changed our mind, we don't want this. And so how that's going to be normally started in the process is there's going to be a ballpark. There's going to be some best guessing going on and the entity will sign an option agreement with the landowner, which is a memorandum of it is recorded in the register of deeds. So it's going to be tagged to that parcel, and it creates an option right in the land trust or conservation district to continue to pull this project through the pipeline to closing. And often the option will be contingent on the property appraising at a certain value, that this figure here being a certain amount. And I have seen it where the appraisal came back and it didn't get there, or the amount of money that the application for funding, or at least the funding portion of this $350,000 from these sources, wasn't quite getting there. And so the issue becomes, well, does how does the option have to be renegotiated and whatnot? The resolution of it I can't cite to you, but that it's just know that that's something that's possibly out there. But our sources here, I've said, an application was made to NRCS for 200,000, application to ADF PTF for 100,000. Different approval criteria, but the entities work together, and there is somewhat of a dance to this. Let's say maybe there was some other sources. Might have been a local county source. Every once in a while, a county does put together some money. Orange County, where I am right now, sitting over the past 20 years, I think at least, has had funds set aside to help with these types of purchases. And let's say that leaves the landowner with $40,000 in unliquidated value that they're not getting cash for. And so generally that's going to become a tax donation, or considered a donation under the Internal Revenue Code 170H, and it can be carried forward. So it's $40,000 in a federal tax deduction. If we're fortunate to be able to need that in 1 year, great, but a lot of folks aren't. And so the Internal Revenue Code and regulations have made sure that that the landowner can carry that forward and eliminate or apply that to future tax years. Qualifying farmers under the regulations can carry that over up to 10 years. So anyways, conservation easement, that's that's kind of the little bit of general there. So what are the benefits when we talk about estate planning? And again, estate planning, I've using the term property disposition, because to me, that's what estate planning is, just a plan to dispose of property. Remember, you can also give property away and sell property. But there are benefits. There's Internal Revenue Code 2031, which allows an executor to make an election to exclude some value of the land, the value of the land that's under conservation easement. I'll admit to you here and now that I've never transacted or made a 2031 election on behalf of an executor or a trustee. And so how the regulations, I know that the regulations do withdraw from that possible reduction in land value. Deduction's already been taken. I don't know how the cash is handled, because in a way, if you think about it, it's sort of like double dipping. So but just know that and all accountants would know that 2031 C is there and available for land under conservation easement to possibly reduce its value further if that's an issue in your taxable estate. But remember, at least for now, and my apologies, I didn't update this figure here for 2023 or 2022, sorry, but it's now $12,060,000 per individual. Keeps going up until 2026. If you'll recall from last session, that it will sunset in 2026 back to 5 million per individual. And so whether Congress steps in or not and changes that is yet to be seen. And as y'all know, there's a lot of factors that go into that. But I also put down is one of the benefits is providing cash money that can be used to, I think a helpful way to think about, or maybe unhelpful, is to buy off the errors. Because remember one of my fundamental principles in planning for the disposition of property in the future is to not create co-tenancies. not create situations where the heirs have to agree in the future how the land's going to be used, how it'll be subdivided, because most of the time that will work within families. Sometimes it does not work within families, and sometimes things happen. People die, say unexpectedly, and interest then devolve to their heirs, and it complicates the situation. So often, and I've been in situations where this became the plan, is that money was set aside to do something like purchase an insurance policy, a whole life policy that would provide a payout to, let's say, off-farm heirs, and then the designated successor that was going to be carrying on the business, or I'll just leave it at that, on the farm, they would get the title to the land. Even though it has a conservation easement on it, still they can pursue their career as an agriculturalist and keep moving forward. And so, but one question I have, and I would love the opportunity to do research on it, is how has this money been spent over the past 20 years? And I'm just tagging that to my career timeline. We've had conservation easements for longer, but these benefits here, I've seen debt paid down, I've seen additional land purchased, things like that. I'm interested as how has that played out over the course of the past several decades. There's, again, that's the 2031C. Property tax benefits. I do get this question often, if I have a conservation easement, do I get, present use value? Well, my understanding is that if you do place a conservation easement on the property as the landowner, it can put you permanently into that, I say permanently, but into that present use value program as a farm without the need to show income. The qualifier there is that you as the landowner could not have received more than 75% of the value in compensation. And so if we go back to this example, I think we're there. We may have exceeded 75% on this. I'm terrible at math on the fly, but that's how that'd be calculated. And if the landowner had received no more than 75% in cash, then they are enrolled in present use value. It also does qualify the parcel for what's called an off-cycle reappraisal. I believe it's an octennial. I know present use value is monitored on an octennial basis. 1/8 of the enrolled parcels are audited, so to speak. And generally, the counties have a cycle by which they reappraise property, and I'm not sure if it's octennial or sooner. I think it's varying now in certain counties, but the statutes allow the county in that year or in the next, shortly after the conservation easement is placed, to go ahead and reappraise the property and put its taxable value, its highest taxable value, at the limit of the conservation easement value, or at least the property with the restriction on it. So that that in itself can reduce the property tax burden on the landowners. The principal effects. So now let's move into property disposition. Again, the principal title effects of conservation easement are this subdivision restriction. And the question here is going to become, we know that there's a subdivision restriction coming. We know that that's what a conservation easement does. So the big question is going to be, how do we avoid, if we have multiple heirs, how do we avoid creating a 435 acre parcel, that'll be my example, that we can now not subdivide, that now we have our 3 children are going to be co-tenants. And as I talked about in part 1 of this series, in co-tenancy, every co-tenant, an owner of an undivided interest in real property, not jointly held, but held as tenants in common, has the right of partition under state statute. And so I imagine, I've not found any cases on this, and I'm eager for a lawyer, a landowner, a clerk of court to contact me and provide me with an anecdote about whether this has ever happened, whether there has been a co-tenant on a parcel that was restricted by a conservation easement, filing a partition action, and what the result was. Because I believe in theory, and I don't see anything in the state statutes that says otherwise, possible that I missed it, that certainly the holder of the easement, the conservation district or the land trust, is going to try to join that action and say to the clerk of court, say, look, you can't subdivide this property. Although it might be possible, as you will see later, but there's going to be a lot of approvals that have to take place. But my concern is that with co-tenants on that property that you can't subdivide, that it could result in an order to sell for a sale in lieu of partition, meaning the property isn't sold and the proceeds are divided up among the co-tenants. So, but I don't know how that plays out, but I would really love to discover an anecdote or a case file number or something like that that I could review. But just know that conservation easement, from everything I'm researching here, in terms of the NRCS conservation manual, state statute, ag development trust fund, program guidelines, subdivision is possible even after the conservation easement is placed on the property. And I'll allude to here and there what some of the restrictions might be. And just to prepare you, we're about to go into a bunch of words on the screen because I've really just been going in and taking language out of the proposed deeds from NRCS for agricultural conservation easements, and statutory language from and even language from the Ag Development Trust Funds manual. I do have an article draft, and you can find this easily on the Farm Law website, where I'm starting to address this issue. I've done this mostly in the context of voluntary ag districts, and have ventured into conservation easements, but have not gone into yet into the depth that I'm going into here on that particular article. But that might provide you some orientation on these issues. So the challenges of coming up with a property distribution scheme that, again, perhaps if I just say, let's keep it simple and say, here's what we're trying to avoid. We're trying to avoid a co-tenancy in our heirs. Now, our heirs may very well be aligned in what it is they want to see for the property to happen, and may take a step on their own to do something like place the land in a limited liability company, like as I described in part 2. I know of in fact, I saw a friend this weekend who does forestry work down in Sandhills, and he said there was somebody did a documentary on a parcel down there where that very thing was done. You had three co-tenants, or actually no, at that time they each had their own parcel, and they made a decision to combine it and place it into a limited liability company for common management. And I think that'd be a great solution, so long as, again, everybody's in line with that idea, and they understand what some of the shortfalls might be for their family down the road. But the challenge is to adapt a distribution scheme, either in your will or your trust, that avoids that co-tenancy, and navigating the restrictions that the conservation easement programs put on these sorts of decisions with good reason. Remember, The ultimate purpose, the principal goal to the public is to put this land aside so it's not going to be paved over, so the soil is going to be there, so it continue to absorb rainwater and help prevent flooding and prevent soil runoff and things like that. So subdivision moves us in a direction where you have more parcels under individual management, and those conservation benefits they start to, I think, diminish a little bit. And so the restrictions under the program are whether, again, ADFP, state law, NRCS manual, NRCS deed, they're all designed to minimize the reduction in what we call the ecosystem values, the ecosystem services that the conservation easement provides us as the public. And this will be in we'll have to do this in our wills and trusts with language, sorry. And in the deed language, really the negotiation, not so much in the final deed, but even in the option agreement, I think, that a landowner might initially sign with with either land trust or the conservation district or another entity. And so these questions should be addressed very, very early on in the process. So let's go into the let's just start marching through some of the limitations here. And okay, I'm doing okay, I think. So first and foremost, there's a federal income tax or Internal Revenue Code limitation, and this is a concept known as the well, at least for the organization that's holding it. I don't know how this impacts the government entity like Soil and Water Conservation District, but for a nonprofit, a land trust, it's a nonprofit under 501c3. This allowing a landowner that, remember a land trust, the reason we're using that word trust in their organizational title, I believe, is because they have a fiduciary duty in many respects to the public to hold this land, that they've taken on an obligation to the public. And their tax-free status is contingent on that. That's the purpose of their organization. If they are to start working deals after the fact with landowners for whom they hold conservation restrictions, that is seen under this concept known as the private benefit doctrine as not benefiting the public anymore at large, but benefiting too few people. And so it poses a particular challenge if the landowner has donated has taken a tax deduction and donated part of their the value of their easement. I could see that as a clawback on that deduction if the IRS were to catch that. But I think it also does threaten the 501c3 of the organization that allows that sort of thing to happen. In my experience, and I've been in several situations on behalf of clients that have made this request, and the answer is no. Not unless additional land can be purchased and added on to the tract. Some sort of modification that at least for who I was working with was out of reach. A colleague of mine, Paige Gentry, we worked together one semester. She graduated from Duke, wrote this great article on it. So you might look that up and really that further. There is an example in the regulations in 1.170814 that if a donation has been made, deductible donation has been made on in the creation of a conservation easement. The only example I could find, and again, this is public, I pulled it straight out of this link here from the CFR, the Code of Federal Regulations. These are the detailed regulations that interpret IRC section 170H. And so this one here, where you have we always call these green acre, black acre, brown acre, 900 acre parcel that has a conservation easement. H has donated a portion of it, but later wants to subdivide the property. And we're setting aside all the restrictions of the NRCS and ADF PTF for now. This is purely from the perspective of the IRS. The example here, and I found this interesting, is saying that SARE cannot subdivide. You can't make that modification and still have enjoyed your tax donation, your tax deductions, because in note here it says that the facts of this, and that facts are always important, it's visible from a nearby national park. Meaning that's one of the reasons. Imagine a bald out in western North Carolina that's been under conservation easement, and it's observable from the Great Smoky Mountains National Park. The reason the IRS is saying that destroys the purpose of that easement is because now you're putting houses in that view shed. But note that this example is not talking about soils or talking about runoff or things like that. So I found it interesting, the specificity of that. And so to me, that says that there's a little bit of there's a door open there under the Internal Revenue Code to not frustrate the purpose of the tax deduction, the donation, not frustrate that purpose, and yet still subdivide the property so long as the principal benefits of that easement, which are listed in the deed, are not compromised. A size of tract still, again, large enough to farm, large enough to provide ecosystem services. And again, I believe that ADF PTF, our General Assembly, the Natural Resource Conservation Service, in a way, all these words I'm about to throw at you have provided us guidance, and what will still allow those values to be maintained and still yet subdivide properties. So let's start with those. So again, remember, I'm Andrew. I'm practicing law. 5-6 years ago, and I have a client that has a conservation easement, and they're doing some estate planning. And I'm like, hey, that's great that you have that. What are our options for subdividing this land if we want to try to go for that at some point, or if the landowner, of course, is talking about doing this in the future or wanting to, it's their desire that a conservation easement sometime in the future be done. How might we move into that transaction? Well, from, again, the Ag Development Farmland Preservation Trust Fund Manual, and I believe this is still current, and Evan Davis can correct me on that. I still believe that there's a minimum size, for parcels that can receive these funds, or landowner of the parcel can receive these funds. It has to be a minimum 20 acres. So what that's telling me is that you can't have a conservation easement on a property minimum of 20 acres. That's my interpretation of it. I don't know if it's particularly relevant, but that's that's something there that gives us some guidance. Now, if we move into 106.744, we have a little bit more guidance in terms of how many lots can we subdivide this. And again, my example will be what, a 435 acre parcel. It's all one tract. How can we subdivide this? What are our limitations? Well, state statute says no more than 3 lots. So we have that as a guideline. Now, I want to point something out, and this is, I'm nitpicking here, but this is under the authorization statute for purchase of conservation easements by counties. We're not here talking about private entities like a land trust. The assumption I would have is that if somebody had standing to challenge such a subdivision, and I believe a neighbor might be, have that standing to challenge it, that whether or not the statute restricts a conservation easement from being divided into more lots. I will say this, and I know there's some of you on the call that are aware of the tract that I'm talking about. Up in Yancey County, a landowner placed a conservation easement on, maybe it was 1,000 acres, maybe it was 600 acres, and subsequently was able to divide those into 25 acre farms. And that's, to my mind, 25 acres is a sizable tract to have a farm on, a local market farm. I don't know how they got away with it. I don't know how it happened. I don't know the details of it. I had 2 clients that owned those subdivided farms over time and sort of had to navigate some of the issues of having the conservation easement on their property. But again, it might have been one that just slipped out. But our statutes tell us that if we have again, let's call it 435 acre tract, we can subdivide that into 3 lots, and that's the maximum we can do. Interestingly enough, just a quick aside, shall be perpetual in duration, provided that at least 20 years after the purchase of the easement. Again, we're not talking about a land trust, we're talking about county. So I don't know how this applies and whether a land trust would ever do this, whether it would compromise their tax exempt status, probably, perhaps, reconvey the stick back to the parcel, back to whoever owns that parcel. It looks like it opens a door that if a county holds an easement, a landowner for a parcel under conservation easement could ostensibly offer to purchase it back, and the county could agree to that, to return that stick to the bundle and remove the restrictions. So they're in the statutes. I've not seen it in operation. I'm not aware of that. Would love to hear about a situation where that was actually done. So let's move on to the federal portion of the funding. So far, if you tracking, we've talked about the federal tax code limitations. We've talked about limitations on the state funding in terms of how big parcels must be, and state statutory limitations, at least for county holders of easements, how many lots can we subdivide. So now let's move over into the federal part of it, where there's money involved. And of course, remember, this is coming from the Agricultural Conservation Easements Program, authorized by the Farm Bill, funded with funding authorized by the Farm Bill and allocated by the annual budgets. The NRCS Conservation Manual, and I'll have these slides on the Farm Law site, so you can click the links and do your own deep dive into it. But the manual that's guiding NRCS offices in their dealings with placing conservation easements on properties, providing funding for the purchase development rights, guidance on how they do it. And so they have a section on subdivision. And so I've highlighted some of the key parts of it. Remember, generally, option 1, usually in a conservation easement, the default option 1 is going to be no subdivision whatsoever. That's fault. That's the one. That's there. That means that whoever owns that land must try later to subdivide the property, and they have to get approval. So it's not subdivision as of right. And one of the things I'm going for here in this presentation is, how do we design a subdivision as of right? And so the deed must address whether you can't subdivide or you can possibly subdivide. And if the plan beforehand is to take the parcel of land and subdivide it in the future, what NRCS national office is telling, I believe this is the national manual, is telling the state offices, then go ahead and get 3 applications on this. Let's not go through that later. Let's go ahead and get 3 applications on the intended, say is intended subdivided parcels. So you haven't had to get the surveyor out yet and get these subdivided with the county, get their own tax ID, get their own PIN numbers, things like that. So that's what NRCS is telling its state offices to do. And say if the eligible entity, instead of prohibiting future subdivision of the protected property, wants to provide a future subdivision of the protected property, this means the land trust is agreeing to this, then the agricultural land easement deed must identify the maximum number of future parcels. We know what that maximum number is, right? And at least in North Carolina, we can assume that it's 3, but again, we don't know how far that statute reaches. And so, and then other terms of future conveyance and things like that. So we're doing this ahead of time, and we're putting that in there. To my mind, if we put in an allowance for a subdivision into 3 parcels, that's what the agreement is. That's the bargain. That's the balance of it. And so that's going to be, I want to call it a subdivision as of right, but there's going to still be a lot of work that goes into designing that subdivision. But to me, that's the gate. If I could highlight it, that's what I would say, that if you want flexibility in the future to not create co-tenancies and subdivide these parcels, this is what you want to have that in the deed. And so a little bit more from the conservation manual, and it divides it in 2 parts. If you identified your subdivision prior to closing, you got to provide that map. You know, that's, again, you're telling NRCS this is what we're planning to do, because NRCS is going to have to ultimately decide whether or not they're going to say this is okay. If after closing, so this is a situation where you already have the conservation easement on the property, but you want to subdivide it. And so note here that there's going to be, it's now a matter of discretion to the state NRCS office, the state conservationists. They have to approve it. And so this is really guidance to them, but the eligible entity must certify that the requested subdivision is required to keep all resulting farm or ranch parcels in production and viable for agricultural use. So again, it's a self-certification, but again, the state conservationist is going to be, making that decision. But note the 2 objective limitations. Here comes impervious surface limitations. So those can't be violated. They have to be allocated among the parcels. So we're not exceeding an impervious surface percentage that's going to reduce the agricultural values, the conservation values of that parcel. We're still forcing that impervious surface to stay low. And I thought this is very interesting, the resulting parcels will not be below the median size farms in the county. And so the state conservationists must turn to NASS, turn to the National Ag Survey, and look at, for Orange County, for Greene County, for Buncombe County, for wherever, what's the lowest, what's the median size farm. And so the subdivision can't be a farm smaller than that. And again, that's going to be county by county. That's one I haven't dug into yet for for examples, but plan to do so in the future, because I think it's some interesting demonstrations. So let's move to the options in the actual deed itself. And again, this is NRCS's agricultural conservation easement deed, the template that they put out, which again, it's guidance to if the sale of development rights is being funded by federal money, then these are the provisions that NRCS is looking for in the deed, so that it's complying with their own guidance and their own programming, and providing, again, in their view, that public benefit. And so you get several options here in the deed. And again, here's the default option: separate conveyance of a portion of the protected property or division or subdivision of protected property is prohibited. So can that be modified later on? Again, that's what we've been talking about. I've not yet seen that happen, but I'm saying theoretically it could. I'm thinking theoretically it could. Option two, again, here's where ahead of time you're saying, I want to make sure that that this can be subdivided in the future. The protected property must not be divided into more than however many parcels. In North Carolina, that, to me, that number there would be 3. Now, if it can be higher, again, I would love to find out how that, how and when that's been done. That would tell me that sure, it can be done. And so, that's option 2. Option 3 is going to be a little bit more detailed, and it's talking about it, to my mind, in reading this language, after the fact. It's saying, it's placing more restrictions. Basically, it's saying that when the owner of the land, the grantor of the conservation easement, wants to do that, then these certifications are going to have to be made, and the subdivisions are not going to run afoul of the regulations that are designing the program. And so, again, I think those subdivisions are what we just went over, medium-sized farm, still able to work as a working farm, whatnot. And so, anyways, again, I think it's fascinating, but there's option 3 in the deed. Again, impervious surface restrictions, and this is guidance to the state director on, what can they waive? How much impervious surface can they allow this parcel to absorb while it's under conservation easement? And so, anytime you do a conservation easement deed, you're going to have the restrictions. Impervious surfaces will not exceed X percent. I have seen it vary. I have seen it applied for, I guess what I call in zoning a variance on that. If greater than 2%, a written waiver from the chief of NRCS must be authorized for it to happen. So let's think of 2% as what our target is for the impervious surface area calculation. I found here in 7 CFR 149122, director may waive up to no more than 10%. At 10%, that's the cap. There would probably be extraordinary circumstances where I think the state NRCS office would go that high. I mean, up high at near 10%, but it's what that's saying is, okay, it's possible. Subsequent conveyances. Now, this becomes very important. I'm rapidly running out of time. You do want to address in the deed that future conveyances can happen. And we know that anyways. Land is always going to be conveyed. If you have a perpetual conservation easement on it, it's going to be conveyed, indefinite times into the future. Sometimes, and I'm not placing a value judgment on this, sometimes there may be an associated transfer fee that's baked into this, where when the property transfers, because the land trust, the holder, has to do some work. They have to get contact information for the new owner. They've got to, they've got to put some time into this. And so where does the money come from to pay for that staff time? So sometimes there'll be a transfer fee that is a percentage of the sale price. And what I always suggest is, and I think this might be done as a default anyways, but if it's a transfer within the family, to a lineal descendant of, say, a grandparent, or if it's a transfer to an LLC, a transfer to a trust, a transfer between co-tenants, those don't incur that transfer fee. I think equity to be applied when it's going to be a transfer outside of the family that's involved with this parcel. So let's now move to, quickly, I'm sorry, but how do we do this into the future? How do we do this in our estate planning documents? So as a baseline, just know that trustee powers in a trust, and remember last week we talked about, or in part 2, we talked about placing property in a trust, and the trustee is the owner of that property. And their responsibilities and discretion and authority in that trust is defined by the trust instrument itself. Well, NC state law or general statutes provides, what default powers of a trustee can be. My practice was to always write this language into the trust itself, so somebody reading it could do that without having to consult the state statutes. But generally, this is trustees have broad powers in terms of property disposition. I just highlighted here, dedicate land to public use or grant public or private easements. To me, that encompasses a default power to enter into a conservation easement for land that is in the trust, unless there's other language in the trust modifying this without the agreement of the beneficiary. So this is a default power of the trustee. I ginned up some sample trust language, and again, this is just me typing on the thinking it wouldn't be in a final document, but it might be, maybe just brainstorming with the keypad. What I might do in a trust that I design, in an article, say Article 5, 6, 7, whatever, disposition of real property, I might have a section in there that says, pursuant to the trustee's powers over real property, the trustee can, I'm specifically saying that the trustee can do this on the property. Now, the question has come up several times in this project, overall Soil and Water Foundation project, about, what if the landowner just runs out of time? Their clock runs down before this gets done. Well, to me, again, this is a possible solution to place the land into a trust, and then the trustee is specifically and directed and authorized to place a conservation easement on, and the Heron Farm, PIN number, I'm in my trust, I was very persnickety about describing parcels of land. I know that shows up, in the county descriptions because that's a family that owned it, 50 years ago. I might also, though, put a time limit that if it can't be done in 5 years, then the property is going to be, then the trustee can subdivide the property and distribute it to the beneficiaries, or just distribute it whole. Again, normally I'm directing the trustee to subdivide property and make sure that we're not creating co-tenancies. But a lot more detail would go in here. What are the lot sizes? Again, syncing that with our restrictions. Who the subdivided parcels go to specifically. Do the trustees, the beneficiaries, get a say? I think that would be a really good practice, is to have those meetings and everybody decide what it is they want, but retain the ultimate authority, because sometimes beneficiaries aren't going to agree on who gets what. And so, but again, I just toss that together as just a kind of a mental exercise, but just an illustration of the possible. But again, remember that though that language is in the trust, the trustee is still going to have to move through what the requirements are with ADF, PTF, and NRCS in terms of allowable subdivisions and those various restrictions. So let's do our sample farm. I think this one's about 435 acres. The only reason I put these boxes in here was to obliterate the roads, so that you can't really identify it. But we have a farm here that's it's a large size farm, in my opinion. It's above the median size for this particular county. And I've taken these screenshots here directly from a baseline report. And so this is the inventory. And this was one of those where I was doing all this work, as the lawyer. Normally a land trust, land protection specialist staff or Soil and Water County staff would be doing this, but all I was doing was making a PDF of the map. And I know this was me because I recognize the font. It's like, this is sort of how I would do things. But here I'm identifying the amount of impervious surface. You see what I'm doing here? There's a farm building there. The roads are paved. I'm sorry, unpaved. Unpaved roads are not impervious surface. At least that's what I believe I've read. But I'm calculating. You see where I'm calculating the impervious surface. So note also, though, in a way, we have 3 convenient parcels. We have them divided by these roads. And so I'm looking at one here, one here, one here, all with great road frontage, water. This one doesn't have a pond on it, but it's obviously going to be able to support well water. And so I've gone through here and done that calculation, and I've added to this easement my calculations. And so this is the baseline. You know, this is where we've established, and notice I'm not going above 2%, so there's no approvals required, at least not to my recollection. I don't remember doing that. And I, somewhat generous, I actually put in the unimproved farm paths, which again, I don't believe those are considered to be impervious surface, only paved. And so here we go. You know, here's the buildings, here's all this. Now, what I didn't do ahead of time was manipulate this image to go ahead and draw my parcel subdivisions. But I just wanted to put this out there to give you an idea of, you know, what you would be looking at on a map with the landowner and trying to make some of these future decisions. And so I just tagged all the buildings here in this particular easement. And then these are the negotiated farmsteads. And I say negotiated because not that it was, you know, not that we're having a big argument over, but this is, we had where you saw the clusters of impervious surfaces, the roofs of the barns, gone ahead and created building envelopes around those. Now, it's certainly possible also that, again, depending on the perkability of the tract, where might you place a housing location on these and negotiate maybe a building envelope for those in that subdivision. And what I'm not walking you through is the step by step on analysis. I'm really just trying to expose y'all to what I view as what's in the realm of possibility. And so again, we have road here, fork there, road there. I see 3 relatively convenient subdivisions that would meet the requirements. I believe each of these are probably going to be above the county mean. I don't know, but you know, we're pretty much resulting in tracts that are going to be near 100 acres apiece. So, and to my mind, I think those would not frustrate the conservation purposes, the soil protection purposes, and with none. And again, you're allocating impervious surfaces, so you're making sure that you're not exceeding those on the individual parcels per the guidelines. Some quick timelines. I know I've run 4 minutes over. Sorry, everybody. Just real quick. Here's a timeline with a trust. Note here that I've had the grantor execute a will into trust. And do they deed the property to the trust? You can certainly do that while you're alive. Well, and so they've done that. So it's in the trust. And remember, the trustee has those instructions in the trust to transact that conservation easement with the third party. Let's say the landowner does not make a decision to transfer by deed to the trust and they die. And their will says all their property goes into the trust. So parcel A gets there one way or another. Well, parcel A has gotten to the trust, and it's going to, in the language of the trust, says it's going to stay there for a period of time. So the trustee with specific powers and maybe some limitations can contract and can do that transaction. And then the resulting parcels, again, we're hoping that we put some subdivisions in there ahead of time, and then the transaction closes, development rights sold, money comes in, parcels subdivided, distributed to the beneficiaries, and then the trust terminates. To me, that'd be all things working out well. Timeline with a will only. This question came up a lot, or comes up. To my mind, to do this in North Carolina, you have to have some sort of agreement ahead of time by the devisees, the future devisees of this parcel. Anyone who's going to get an interest in it has to have an agreement that they will agree to do this conservation easement transaction moving forward. And so kind of the same result, but just no trust. But again, if you're just using a will, I don't believe the executor, because the interests have now gone to the individuals at the date of death, the heirs. And the clerk of court has an interest in closing the estate, and that closes the executor's power. And the land isn't even an asset under the authority of the clerk of court, unless it needs to be liquidated to pay debts. It's something that's just already owned. So I think a pre-agreement has to happen and have a memorandum recorded prior to the death, so that the the heirs are obligated. They've received this parcel that has this agreement attached to it, and they now, whoever owns the interest in it has to proceed. The last one I'll put up here, and this is normally how it would, I think, the transaction happens anyways. The entity, third party, land trust or whatnot, is going to execute that option agreement, right, with the landowner who wants to go ahead and do this. And the option agreement is going to be recorded in the register of deeds in the chain of title. As a memorandum, may not, have all the details in it, but it's going to run with the land. So it doesn't matter, to my mind, who inherits this property. The property came to them, their interest came to them with a string attached to it, and that was the option. And if the optionee, the third party land trust or county soil and water district wants to pursue it, then they have that right to do so. They've already purchased that right, so to speak, to proceed to closing. Now the question remains, how cooperative are people going to be? I can see several procedures for doing that. You might have to go to a judge to do it, but I'm seeing it within the realm of possibility that somebody could be appointed to make sure that option's carried out. If I were the land trust or whatnot, I would be addressing those issues, in terms of what that process might look like ahead of time. So anyways, that's a timeline there. Sorry, I did go over time on the presentation proper. Again, I want to thank Orange County for providing me space here in their extension office. I live in Chapel Hill, to do these. That's been really wonderful and convenient. And of course, we have our funders. I'm psyched that the Soil and Water Foundation asked me to do this. It's a lot. It raises a lot of interesting questions, and I hope I haven't been talking about this a little too excitedly or a place way up here. There's just a lot of detail in there. Just again, this is an exploration of basic rights and property, basic methods by which property is disposed of through estate planning, through gifts and sales, and how the conservation easement might impact that, and what the restrictions are in the programs that authorize the easement in the first place. And so that's kind of a summary of where, of where we've been. And so that's that.
Andrew, you do have a couple of questions in the chat.
I see. Yeah.
Yeah.
Okay. Yeah. There's okay. So somebody did ask me directly how to review the recording. These will be Gail will send out a follow-up email when they do that work. I know there's probably some editing of on the front that needs to be done, and I'll take those and I'll post them for my purposes and whoever comes to the farm law portal on the farm law portal. And again, to find that, just Google farm law NCSU and it'll pop up. It gets pretty high up there. So the ballpark. One question is there any way to ballpark the cost of monitoring? I'm going to say that's outside of my experience. These are formula that land trusts have worked out. I mean, they've been doing this now for 30, 40 plus years. I believe that there's a lot of guidance within the land trust community for how they've estimated these and how those estimates translate into a possible ask for a cash donation for what monitoring might cost. I do know that they hold funds aside in vehicles so that they can, of course, so that they're set aside and they're there to pay staff for monitoring. They don't take those funds and just pay the rent. They do use them for that purpose, and in my mind, it's a fiduciary obligation. The money's also there though to defend. If they need to hire a lawyer to stop a landowner from violating an easement, from doing something, the money's there too. But it's a really good question. I just don't know the answer to it. It's one that I'm sure there's some guidance out there on the internet in the land trust community. So. Other question. What if you have several contiguous parcels that you wish to place under a conservation easement, does the size of the constituent parcels have to be of a certain amount, either individually or in total? That a great question. I think that was, you might have asked that before I went through those slides showing what some of the limitations in the state statute or and from the funding sources are. While again, the state statutes, at least those that I've been able to discover, don't put a floor on the minimum size that a conservation easement parcel might be. Because remember, we're also, conservation easements are also broadly defined for purposes of historic preservation and things like that. So there's also definitions on their use in the state statutes, but you might have a facade easement or a preservation easement on a house or a structure, something like that, which would be small in acreage. But we do know that if Ag Development Trust Fund and the North Carolina Ag Development and Farmland Preservation Trust Fund is in there, that they have a 20-acre minimum. And so that's going to be, to my mind, the floor. And then I believe that I didn't see where the NRCS guidelines were putting a floor on the size either. Yeah, and I have to leave it at that because I haven't discovered that yet. I haven't seen where that is. The only limitation I've seen so far has been in the Ag Development Trust Fund's funding. But yeah, that's about as far as I can go on that. Sorry. But his questions come back. Was that for the parcel in total? It's, to my mind, that's individual parcels. So I am not sure, and I don't know if ADF PTF staff has addressed this issue before, but I think if I was trying to step forward and ahead of time design a subdivision scheme that was going to be less than 20 acres per subdivided parcel, I think ADF PTF might balk at that. They may be like, nope, you're reducing those too small for our purposes. Just my take on it. Again, that's something that might discover more information about it in the future. But no, that's for individual parcels. Because remember what we were talking about was subdividing these parcels, and each of them have their own conservation easement on it. And so that minimum from ADF PTF would apply there. And Amanda, thanks for jumping in here. I'm going to move your chat over here so people can read it. And I hope this wasn't just, I don't think it was just to me, it's to everybody. But I don't want to be your voice. I'm just reading. Yeah, thank you. Yeah, this was my what I suspected, not is the wrong word for it, what I figured probably was the case. But yes, Amanda from Catawba Lands Conservancy has put on here, their formula. They have acreage, location, how difficult the reserved rights in the easement itself, like how difficult it's going to be to monitor. They're going to have to, really walk the whole property, make sure that things aren't happening. I mean, I've walked property with land trust folks before and, noting deer stands that shouldn't be there because that easement didn't allow for it. It was a particular type of easement. And so yeah, she said that those funds are set aside, and that was my assumption too, that they land trusts don't access these funds except for those purposes, and so they're always going to be available for monitoring. They're always going to be available for legal defense and things like that.
Okay, this is Gail. Is there any other questions for Andrew and Amanda? We really do appreciate you, putting that information there about your land trust, yeah. And I'm sure that's very similar to all. Is there any other questions? Beth saying would like a little more clarification.
Okay, let's see. Let's go back here. So Beth, I think what your question is, and feel free to turn on your mic and we can discourse
yes.
on so in my example here, this my recollection is about a 432, 435 or so acre parcel. So that's a nice sized piece of property. There's no, the only minimum I can find, again, if we're looking at this as one parcel and I want to place a conservation easement on it, the only minimum I'm finding, and again, that's if I'm using cash from, or I'm asking for cash from the Agricultural Farmland Preservation and Agricultural Development Trust Fund. I keep getting the words mixed up, sorry. I know that I have to have a minimum of 20 acres to go and ask them for that money. Well, I've exceeded that, you know, by 20, right? And so by 20 times. And so I'm not worried about that. But when we talk about if either ahead of time or in the future, if I want to go ahead and apply to the county to have, or at least propose in a map to Ag Development Trust Fund, that I want in the future to subdivide this property. If you see like moving along the road there, so you're going to have this be one parcel, parcel A, parcel B, and then on the other side of this road down here, parcel C. Again, to my mind, I'm not speaking for the trust fund, but I believe that I could not create a subdivision of this parcel that maybe would just be a little chunk up here that was under 20 acres.
I think my question is really more from the other side. I already have property that's subdivided in contiguous pieces that are smaller than 10 acres apiece, some of them.
Okay.
But when you add everything together, the property is more than 20.
Okay. So
that's my question is I've already got pieces that are contiguous and subdivided, have their own pins and, you know, all of that. We want to put the whole thing under one umbrella in terms of an easement. Is this pre-division of the property problematic?
I don't believe so, because I believe that you can probably, I don't know if a combination would be required, but you're certainly able to combine the parcels. There's that step. You may not wish to. Now, and this is a really good question, and I know there's an answer to it. And if Evan's on the call, he might jump in and say this is, or any land trust say this is how they would approach it. But you know, it might be that each owner of an individual parcel is agreeing to the deed of conservation easement, you know, subject to that easement being on all the other parcels too. It's possible. I'm not sure if their, you know, their rules would allow that absent a combination of the property. But I could see it's possible that all landowners of the individuals do that and, you know, agree to the same conservation easement on their individual parcels, and it's monitored as one parcel. I'm not exactly certain, and whether or not that would be an exception to that rule that PTF has about the 20 acre minimum per parcel. I don't know, but I see exactly where you're going with your question. And that would be a great question, I think, probably for, you know, Ag Development Trust Fund staff, NRCS staff, or particularly land trust staff. How would they look at that particular situation? Do you see what I'm saying?
Yes. Yeah, well, I mean,
it's just,
I mean, it's all one owner, and we actually have a trust. I mean, we've got things set up so that, you know, at least from the legacy, the disposition of the real property, we've got things set up in such a way. What we don't have at present is the specific pathway to easement.
Sure. I think you might be asked to recombine the properties, which is certainly, you know, it's a process, but it can be done.
All right. Thank you.
That might be the request. So, I mean, no, Amanda, please jump in. Yeah. Okay. So Amanda Byram from Catawba Lands Conservancy out in the Western Piedmont is out for the west of here, They're saying yes. That's Beth, and answer your question is they've done that before. You know, she's just speaking on their behalf, but that puts it right there in the realm of yeah, it's something that you could do. Yeah, they're looking at the total area. So, but what else? What else? Anything else? Really appreciate this opportunity. You know, thanks all of you for logging in and listening to me prattle on for 3 straight weeks.
We do appreciate everybody's participation, and Andrew, especially your knowledge and information that you have shared with everyone. I did put in the chat that the foundation, we've got several projects wrapping up and a big meeting tomorrow to prepare for. So it will probably be next week, but I will be emailing everybody who registered for these sessions. I'll be emailing you a link to all 3 of the sessions when we get them all downloaded and you know, sort of taper down from get them ready from so you don't have a lot of extra recorded information. So we will get those out. Look for them next week though. Look for that link. Is there any other questions? It looks like Beth has put her email. If people have some questions specifically for Catawba Land Trust, she's put her email in there. All right. Again, thank you, everyone. Do not hesitate. You've got Andrew's contact information there on the screen, as you can see. Of course, you can email me also. And if, you know, if it's something, I'm not the expert, so I would definitely pass it to Andrew or others that I know in this realm of work that can answer your questions. We'll try to find you the answers. So, but
I'm just not an expert either. I just think I know what legalese looks like.
Yes.
Oh, that's legalese.
That's legalese, exactly. So, all right.
Thanks, everybody.
Thank you, everyone. Have a good rest of your day.
Thanks, Gail. We'll talk soon.
Thank you, Andrew. Appreciate it very much.